No.
No.
It's so awkward.
Oh no, it's the worst thing I can.
Yeah, we did.
Court right of able.
Yes, my lords, there is more that I could say in relation to municipal mutual, but I'm afraid in the interest of time I need to move on to WASA. Before I do that, can I just pick out one point in relation to a question or comment from Lord Justice Popplewell earlier about the significance of market practice of the treatment of business interruption. It is, if I may say so, not a complete answer for this reason. It is, of course, right that even after the insured peril, whether it be property damage or whether it be enforced closure, has stopped operating, so when your hotel is repaired and open or where your restaurant is open, your business interruption may still continue. You may have lost half your clients. It takes some time to get your business, as it were, back up to where it was before. What we're actually talking about here, when we're looking at various eateries in particular, is not really the interruption to the business or the effects of the business continuing. It's actually the peril. It's the enforced closure continuing over the end of the policy period. And if that's right, then the right analogy would be damage, if that was the relevant peril, also continuing over the policy period into the next policy year. So I quite take my Lord's point that there certainly was a debate in various eateries, and I think some of the other cases too, about market practice in relation to business interruption. It is, we would say, not a complete answer. But on that basis, can I move on? WASA and Lexington is the next case I wanted to look at. It is, as I've already said, factually, it's a rather different case, both to this and actually it's a different case to municipal mutual too. We'll find it in our authorities bundle at tab 44. And as I explained earlier, it was a case which involved underlying contamination of 58 sites in various locations as a result of the generation and disposal of products back to the 1940s. The issue that arose was a rather different one to that in municipal mutual. The periods of the insurance and the reinsurance were the same, but the applicable laws are different, and that gave rise to a number of problems. I want to deal with this, if I may, fairly quickly, just by focusing on the relevant passage. The judge, in his judgment at paragraph 72, said that, quotes, it is common ground that the issue now being considered was resolved in WASA, but with respect to the judge, that wasn't common ground at all. WASA was a different case. We relied upon WASA not for its facts or for its resolution of this issue, but because of what Lord Mance had said in paragraph 39 of his judgment. And perhaps we can go to that straight away. It's at page 1098 of the bundle. And this is in a section of the judgment where Lord Mance said that the position in, or the answer in WASA could be resolved by reference to some 7 propositions. And what we're about to look at is his 4th proposition, And you'll see it starts about half the way down page 1098. And I'm not going to read it all out, but if you pick it up about 5 lines down, you'll see it says the only property damage was the reinsurance construed according to purely English law principles covered is property damage occurring during the 3-year reinsurance period. And he then explains that conclusion in the following way, or rather he supported it. You will see this at 39. This construction of the slip also reflects the basic principle of English property insurance law that the insurer is liable for a loss actually sustained from must be peril, insured against during the continuance of the risk. There's a reference to night and faith, and then you'll see in parentheses about night and faith. He says this: the emphasis in that case was on the need for the peril insured against to occur during the continuance of the risk, damage materialising or developing from it after the policy period would still be covered. Now, WASA...
Is that an accurate... Well, at some point you'll doubtless tell us whether that's an accurate summary of what night and faith actually decides.
It's an accurate summary of the argument that was accepted in night and faith, albeit on the facts of the case, the argument didn't work. So that principle was recognised in night and faith. The confusion arises...
Night and faith was neither a materialising nor developing damage. It was a ship that ran aground.
It absolutely...
Single event.
It was indeed. There was an argument that was advanced in night and faith that although the ship wasn't, as it were, immediately a total loss, nonetheless it had become a total loss later when the master sold it after the end of the policy period, and the court said, oh no, that doesn't work. But in the course of the debate, there was discussion of a very old and very badly reported case, a controversial case called Meritoni, and it's in that discussion that you see it's the Lord Chief Justice accept what's sometimes called the death blow principle, sometimes called the grip of a perils principle, namely that where you have an insured peril which operates during the period of cover, and here it would cause some damage, but where the damage deteriorates later, so the vessel becomes a total loss, which is where this argument very commonly arises, that is covered. The word used in night and faith was ascertainment, and certainly on the facts of that case, one might read that as meaning discovery, namely, as you say, vessel grounded, she's then kept afloat, she's beached so an inspection can be carried out, and at that point they realise that the damage is what it is. You might say, well, ascertainment is used to mean discovery. In our submission, if you read the case as a whole, that would not be right. It's embracing a situation where the insured peril happens, and the damage may be later discovered, or it may develop so that the vessel then becomes a total loss. And that's really the principle. And you see, I'm tempted to say...
There was no suggestion in Night and Faith that there was any deterioration or worsening of the damage. I mean, it just ran aground and it was pumped.
That is absolutely the case in terms of the facts of Night and Faith. But what one sees, and we've now seen it referred to by Lord Justice Hobhouse in Municipal Mutual. We've seen it here referred to by Lord Mance, who specifically uses the word developing. We're about to see it referred to by Lord Sumption, who treats it in the same way. And all those 3 judges, all, if I may say so, hugely experienced in insurance law, accepted that that was the principle that Night and Faith established. As I say, one can read the authority and one can say, well, the word uses ascertainment. But that has been recognised for some years as the Night and Faith principle. But anyway, that's the passage in WASA I wanted to show you. Like Municipal Mutual, that is a non-marine case where the insurances and the reinsurances contain what one might call a damage occurring trigger. So Lord Mance certainly didn't regard Night and Faith as relevant only in a marine context, or where the trigger event was a peril or a casualty. I mentioned Lord Sumption. The next case I wanted to take you to is the Renos, please. That is in tab 60 of the authorities bundles. Now, just by way of very brief introduction. The facts of the case don't matter for our purposes.
Sorry, which tab? Sorry.
I'm sorry, it's tab 60, starting on page 1496.
60.
60.
No, thank you.
It concerned a vessel which was damaged by fire whilst on a voyage in the Red Sea, and the vessel was towed to Suez, a notice of abandonment was served, and a claim subsequently made against hull and machinery insurers for a constructive total loss. Common ground that the vessel had suffered loss by an insured peril, and the issue was as to the measure of indemnity. There was a particular issue about what costs could be taken into account. Now, we're not interested in any of that. What matters, and the part I rely upon, is a passage in the judgment of Lord Sumption, who gave the only substantive judgments, where he said that the answer to the question depended upon some basic principles of insurance law. And it's part of that which I wanted to direct you to. And it's the passage that is in paragraph 10 of his judgment. It starts on page 1503. It's a lengthy paragraph. I'm not going to read it all out. It starts with some basic propositions about the nature of an insurance contract and the fact it gives rise to a claim for unliquidated damages. You'll then see reference to Chandris and Argo, which is a decision of Mr. Justice McGaw, where Mr. Justice McGaw pointed out, and one sees this, that it's not a fact that must exist and be pleaded that the plaintiff has quantified the amount of his claim, or even that all the facts exist at the date of the writ, which will enable the proper amount of the claim to be determined. So that contemplates that things may still be, as it were, happening, as at the date of the writ, which are relevant to quantification. And then Lord Sumption says this: the rule that the loss is suffered at the time of the casualty applies notwithstanding that the loss developed thereafter, unless it developed as something that can be regarded as a second casualty, breaking the chain of causation between the first one and the loss. For that reason, it has been held that the fact that the policy expires before the loss has fully developed will not affect the assured's right to recover it in full. And then he refers to actually the same passage in Knight and Faith that I think Lord Mansard referred to, page 667. And you'll see a reference there to Wasser, and also to a comment made by the learned authors of Arnold. If a casualty occurs within the policy period and the loss develops after its expiry into one which is constructively total, there's still a constructive total loss under the policy. So I take my Lord's point about Knight and Faith, but we here have another judge, highly experienced in insurance matters, regarding that as extending to developing loss as well as it were, discovery. And one sees Lord Sumption making that. I mean, the Renos is a marine insurance case, but he makes the point he does by reference to both marine and non-marine authorities, including in the non-marine context, Wasser. And that statement of principle, including his comments about developing loss, is, we would say, consistent with Wasser, consistent with municipal mutual, both non-marine cases concerning a damage trigger, and also consistent with what was subsequently said in various eateries, which I showed you this morning, and in Unipolsci concerning first principles of losses occurring, insurance and reinsurance.
And is this a rule which applies irrespective of the wording of a policy?
Well, that cannot be right.
Well, I don't know, it just says rule, so I'm just asking the question.
Well, it's a general principle of insurance law. There are, I think we referred to one case actually in our skeleton argument, I wasn't going to take you to it, where a policy did actually refer to loss occurring in its entirety during the policy period. It was actually a policy expressly covering pollution. Now, anyone who knows anything about insurance law relating to pollution will know that temporal scope of policies is critically important. So one can see in a policy...
But are you saying that without some such wording like that, this rule would apply, so that if you want to exclude damages, developing damages, let's call them for a second, you need to make it clear in your policy wording that you're excluding this from the rule?
You need to make it clear. I mean, if there's an exclusion, obviously an exclusion will take precedence. It's just excluded, that's it. We certainly don't have an exclusion.
I didn't mean exclusion in the technical sense. I meant if you want to not have your policy read this way.
Yes, and I think at an earlier stage, I said that what I was putting forward was put forward as the general position, by which I meant that it would always be possible for parties to, as it were, contract out of it. But if they haven't, we would say you need some pretty clear language because it's a fairly well-established principle. Then what you have, you have what you have. You have a losses occurring during policy, and whether the loss is bodily injury or property damage or an event or a peril, if it starts to occur during the policy period and continues after, you have cover for the whole, so long as you don't have some intervening cause. And of course, in many cases, you well might. If there was an opportunity to stop damage and failing to do that would involve a failure to mitigate, then that might be a problem. If there was some new intervening event, so let's say more rainfall that caused different damage, Mr. Wrigley's drain or water main example, well, that might be different. But the ordinary rule under a losses occurring policy is whatever it is that has to occur during the policy, if it starts during the policy covers the whole, as a general rule.
So, did you put it this way? It's a principle of construction as to what the simple wording losses occurring during means.
Yes.
In the same way as the general rule is that when policies talk about losses caused by, they mean proximately caused. Yeah. But you can have wording in the context of proximately caused, which makes it clear that it's confining it more narrowly.
That is exactly what I mean.
And you say the same applies here.
I do, and I rather hedge my bets when I started by saying it's a point of construction and or law. It is actually, in truth, really a point of policy construction. But losses occurring during policies, as one sees from the authorities I've shown you, are interpreted as operating on the basis that if the thing starts during the policy, then it is covered as a whole. I've mentioned a couple of times Night and Faith, and obviously I've been asked some questions about it. Before I was asked questions, frankly, I wasn't going to take you to it, A, because of time, but B, because in circumstances where Lord Justice Hobhouse and Lord Manson's assumption have explained what it meant, it might be said to be rather impertinent, but I'm happy to look at it.
Speaking entirely of myself, I'd be pleased to be shown the passage you've identified.
Yes.
Well, the Chief Justice's judgment in the course of discussion, which gives rise to the principle, even though not on the facts of the case.
Well, it's in, as you might expect from its age, it's in tab 1 of our bundle.
Top of page 12 of the bundle.
And as has been put, I mean, factually what happened is that it's a policy for 12 months from the 24th of September 1845. Towards the end of the policy period, the vessel grounds, she's got off, she's brought into port, she discharges her cargo, she then remains there until the middle of the next year when she's beached, so a survey is carried out, and she's then to be found to have been so damaged by the grounding that the repairs couldn't be done at that port or elsewhere. And then, in October 1846, that's after the policy period, it's the vessel sold by the master, who was also her part owner. And if you look, first of all, if we pick it up, I'm going to use the numbers in square brackets in the judgment. Top of page 6, 651. Although the vessel received her death blows by the said perils of the seas on the 16th of September.
I'm so sorry, where are we?
I'm at
651, did you say?
651.
Yep, I'm with you now.
You will see a reference to the death blow principle, and it's that principle for which the authority is most usually cited. below that, you'll see,
Then it says the extent of the damage was not ascertained until after the 24th of the same month. That's the end of the policy period. I find it really difficult to read that as meaning anything other than they didn't find out how badly the ship was damaged until they beached her and
yes.
examined it.
Well, I think that must be right.
I mean, that's what ascertained means.
Well, that's what ascertain might mean in the sense of discover. It might also mean that where you have loss which is developing, then the full amount of your loss caused by the insured casualty.
Where is the evidential basis for your reading of that sentence, that the extent of the damage was not developed until after the 24th of the same month? There is no possible basis on this recital of facts for an assertion that the damage was developing in that intervening period.
Now, on the facts of that case, it didn't work, and the only argument was effectively that the vessel had become a total loss at a later stage after the policy ended, at a stage when it was told, and that argument was rejected by the court. The passage I was going to direct you to, if I may, is the passage immediately before the passage that Lords Manson and Sumption referred to. They referred to 667, which starts at the bottom of page 11. If one looks at the authority before that, you will see there is a debate about an old case called Meritonian Dunlop, said to have been decided by Lord Mansfield. The only account of the case is actually in another judgment, which is a rather odd proposition. And just looking at the top of page 11, this has been supposed to lay down the rule that where there is a time policy on a ship, even the ship within the time receives damage, however severe by the perils of the sea, but the amount of it is not ascertained until after the time has expired. Until then, she's kept afloat as a ship, although from this damage she afterwards sinks or is found to be in a state where she's not fit for navigation and incapable of being repaired. The insurers can be neither made liable for a total or a partial loss. That's the supposed principle of Meritonian. That's then discussed, and if we drop down about halfway down the page, you will see the Lord Chief Justice says the indisputable principle in cases of life insurance cannot be applied unconditionally to time insurances against perils of the sea. In the first class of case, the insurer is bound to pay only when the insured dies in the time mentioned, and is free from liability when the insured survives that time. A middle condition between life and death cannot be recognised. On the other hand, in the last class of case, there really exists a middle condition for which the insurer is likewise answerable between the sound condition and the entire loss of the ship, viz. Damage without immediate destruction. And then you'll see it goes on, supposing the ship, while the obligation lasts, is to come into this condition, is there no ground to absolve insurers? In justice, therefore, the question is then not whether the insurer is to pay at all, but how much he is to pay. Then you see discussion of some American cases. And then at 667, you get the passage which is referred to by Lords Manson and Sumption. And at the top of the page, page 12, you'll see the Lord Chief Justice says, we very much doubt whether any such doctrine was ever laid down by Lord Mansfield in Meritonian. Doctrine seems contrary to the principle of insurance law that the insurer is liable for a loss actually sustained from a peril insured against during the continuance of a risk. And if a ship insured for time, during that time, receives damage from the perils, although the amount of it is not ascertained till the expiry, and she's kept afloat until then, upon the insured taking proper steps, giving notice of abandonment or by obtaining evidence of some which would be required, no good reason why they should not, according to the facts, proceed for a total or a partial loss. And then below that you'll see a reference to Lockley. Said, we don't think Lockley is authority against the plaintiffs, for there the proximate cause of the loss was the seizure by the government, which occurred after the policy had expired, while the proximate cause of loss here was the grounding off Santa Cruz while the ship was still protected by the policy, and immediately and directly some damage arose by which the value of the subject matter was lessened. So, my lord, you're absolutely right that the case talks about ascertainment, and certainly any argument that death blow worked on the facts. It's not right. But in those passages, in the analysis of Meritonian, the recognition of a middle ground between a situation where the peril operates, some damage is suffered, the policy then expires, but matters develop so that the vessel becomes a total loss.
Well, the middle ground that seems to be suggested is you recover for your partial loss, not
Well, that was what happened with the
recover
facts.
for a total loss. The passage at the end of the paragraph on 611, using the report pages, supposing the ship while the obligation last come into execution is assuredly no ground to absolve the insurers from all liability. Justice, therefore, the question is not whether the insurer is to pay at all, but how much he is to pay. And then you get the same again at the top of the following page, saying there's no reason why they can't proceed for a total or a partial loss. As I read it, it is Meritonian is being relied upon to say, if you haven't suffered all your damage in the policy period, you can't get any of it. It's not as black and white as that. If you've suffered some during the policy period, you can recover what you've suffered during the policy period.
But the question may be, if I may say so, what is meant by the expression how much the insurers are to pay, whether that is to be determined simply by the state of the vessel as it was at the end of the period, so for example before a vessel has sunk and before it became a total loss, or whether actually what is being talked about is ascertainment in a broader sense, namely the facts, we saw this in Chandris and Argo in the reference, the facts are still developing which may affect the loss that the owner has suffered as a result of the insured casualty. I can't put it any higher than that. We can see what Knight and Faith says, but we can also see how it's been interpreted by three extremely eminent judges as well as the editors of Appellant. But there we are. Can I move on? Because I'm very conscious of time.
So are we, but this is
it's important.
Perhaps your most important point.
Well, quite. But I'm very conscious I need to leave time for Mr. Windsor sitting next to me. I said I had three overarching submissions. That's the first, which I've spent some time developing. Second, coherence. An approach that treats continuing or developing damage for the purposes of the policy as it occurring in its entirety at the point of onset. We say that would be consistent with the way in which continuous injury and damage is treated in other legal contexts. Now, in relation to limitation, for example, it is trite that a cause of action in tort is regarded as accruing at the time some actionable injury is suffered, even if injury or damage continues thereafter. In the case of bodily injury, that's cartilage and joppling. In the case of property damage, the authority is Pirelli and Oscar Faber. They're not in the bundles because the authorities and the proposition is too well known. A similar point arose outside the limitation context in a case called the Starsin, which concerned progressive damage caused by condensation. It concerns parcels of timber which suffered from condensation damage during sea carriage, allegedly due to negligent stowage. What happened and what gave rise to the issue was that title in the parcels of timber passed from one owner to another during the course of the voyage, and there was then an issue as to whether the second owner could pursue a claim in tort against the ship owner on the basis that the part of the condensation damage that occurred after that second owner acquired title constituted fresh damage in respect of which that second owner had its own cause of action. And Lord Justice Ricks, who gave the principal judgment in the Court of Appeal, said no, and the House of Lords agreed. Now, I'm only going to, in the interest of time, can I show you one paragraph in Lord Justice Ricks's judgment? We need to look at it in tab 24. And I want to go through, please, all the way through to page 482 of the bundle, paragraph 105 of the judgment. The earlier paragraphs merit reading, but in the interest of time, I just want to show you this paragraph. Look at 105. It's a long paragraph. I'm not going to read it all out. You'll see Lord
Can you
Justice.
just give me the page number again?
If you're looking at the bundle numbers, it's 482.
Thank you.
Lord Justice Rick starts by saying that Mr. Berry is right in his submission about various substance cases and also cartilage and Pirelli. If you can drop down about halfway down the paragraph around E, moreover, in the case of progressive damage, I would not agree with Mr. Jacobs that a new cause of action is created each time the object suffering damage comes into the hands of a new owner. It may be different where entirely different damage is done on different occasions by reason of a different defect, as where, owing to defective hatch covers, one hold is flooded on one day and another hold is flooded on a different day. But that's for another occasion. In my judgment, the progressive damage done in this case does not create new causes of action in respect of the later stages of the same progressive damage, even in the hands of a new cargo owner. As I say, there are earlier paragraphs that are relevant, but that's just an example that the point I've made, it's not just a sort of esoteric limitation point. It arises in different contexts as well. And as I said, I think when I started, although coherence and consistency may be desirable generally, actually they're important in insurance law, because if you have a liability policy, there is going to be an interface between the claim against the insured, say a claim in tort, and the coverage under the insurance policy. So it would be very odd if you had a situation where there's progressive injury or progressive damage. For the purposes of the underlying claim, cause of action accrues in relation to the whole lot on one day. But for the purposes of the insurance policy, operating on a losses occurring during basis, one somehow had to parse the damage. That's just it's a very odd conclusion, and it might, in particular circumstances, lead to some very odd results.
I'm sorry to hold you up, but just going back, your other analogy with bodily injury insurance.
Yes.
You showed us the Bolton case, but it didn't actually
It doesn't cover
cover
this
this
particular
directly, and mesothelioma is a slightly odd creature in this context. But if you're right, I would expect there to be quite a lot of personal injury cases in terms of developing diseases generally, which would illustrate the point. But you haven't found one.
I haven't found one, I'm afraid, and that may simply be a reflection that the debate
Is obvious, you say.
is obvious, namely that it's treated the policy that responds if it's placed on a losses occurring basis. An employer's liability cover is different. But if it's losses occurring, it's the time when the injury begins. And I mean, it's slightly startling that one hasn't seen an insurer take a point that, well, you start with damage in the lung, cancer in the lung, it then spreads to some other organ and then some further organ. You have an insurer saying, well, I'm only liable for the lung, and the chap on the next year is liable for, some other organ. One can see why nobody's run the argument. It also gives rise to this issue, and this is where I was going to go lastly on this topic, which is commercial consequences. It was my third submission. Yeah. A conclusion that in the case of developing damage, the whole of the damage is treated as occurring at the time when it begins. That, we would say, makes commercial sense, because its effect is that where successive time policies are placed on a damage occurring during basis, then indemnity for the whole of the damage will generally be provided under one policy or the other, without any need to parse the damage, which, as you'll appreciate, evidentially might be rather difficult. I mean, you'll recall Lord Justice Hobhouse's surprise in Municipal Mutual at the proposition that the same damage might be covered under two successive policies. And of course, his fire example, or to be fair to him, Mr. Justice Waller's fire example, that his treatment of it postulated that that wouldn't occur. It would be the policy or the insurer on risk when the fire started and the damage started who would bear the whole.
Well, I'm not quite sure why that's surprising. You'd have to conduct that exercise to work out whether the damage occurred during the policy period at all. If you had a fire, and you had to try and decide whether any damage was caused.
Oh, well, yes. Well, of course you'd have to work out if any damage were caused. But, I mean, one thinks of a simple case of fire starting at 11:30 at night before the policy expires at 12 o'clock. It starts burning along a beam, and by 12 o'clock it's got so far, and by 1 o'clock in the morning it's got a long way further. Do you really have to pass and work out, well, exactly how far has it got at 12 o'clock at midnight?
You do,
And
because
what repair will be
because if it
required?
hasn't got as far as causing any damage, then that's a relevant question.
That I agree,
So,
but once you've
You
got...
may have to do, it may be a different parsing, but examining the effect of the peril.
If the question is, has it caused some damage, I agree, you have to satisfy that criteria. It's the word that actually Lord Justice Hobhouse used in Nakila. There has to be some damage during the policy period. And I accepted at the outset, this policy has a damage trigger. There has to be some damage that has occurred during the policy period. The question is, if you've jumped that hurdle, you've proved there is some damage, does the policy cover the whole? In my, no doubt, rather stupid example, does it cover the cost of repairing half the beam or the whole beam? So that's the point. The other point about commercial consequences, of course, is I mean, it goes to the point that was made actually by Mr. Justice Butcher in Eateries, but also by Lord Sumption in the Renos. If you have an insured peril which has begun to operate, or property damage which is ongoing, how could a policyholder secure subsequent insurance, bearing in mind his or her duty of disclosure? Even if some insurance could be secured, as Mr. Justice Butcher remarked, would any subsequent insurer impose an exclusion for the damage or the peril which was already on foot?
Well, it might go further than that.
Well, I'm about to.
There wouldn't be a fortuity.
Well, that was my next point.
Sorry.
Even with no. Sorry. I'm always very grateful. Even without an exclusion, would the subsequent policy respond where some damage had already occurred and subsequent damage was inevitable? I mean, the answer to that question, we would say, would likely to be no. Any further damage would be regarded as non-fortuitous. And if one wants to use Mr. Justice Waller's fire example, it would be literally insuring a burning building. So if I'm wrong, then a whole raft of very surprising and very unsatisfactory commercial consequences arise. And of course, as Mr. Justice Butcher pointed out in Eateries, the position is acute if the damage commences right at the end of the policy period. You might find an insured who only has a few days of cover and little or no prospect of obtaining cover under any future policy. Now, the insurers have tried to grapple with this in their skeleton argument. It's paragraphs 25.3 and 24. But the way they've done so is wrong. The principle that insurance policies insure against fortuities, it's a principle of construction. And that means that the question of whether a loss is fortuitous or non-fortuitous falls to be judged at the time that second policy attaches, time the risk incepts. So a fire that commences after the inception of a year one policy will be fortuitous for the purposes of that policy. But if it's ongoing at the time the year two policy attaches, then it and the damage will be non-fortuitous. It's the burning building. Now, my lords, conscious of the time, I want to leave that issue and move on to ground four, which I need to deal with.
Just
yes, I'm
before
sorry.
you do I take it that nobody is suggesting, or you're not suggesting, that we are in any way bound by any of the undoubtedly learned dicta that we've seen in any of the cases?
Well, having told you, I think a little while ago, that the point is ultimately a point of construction, I think my answer to that question must be no, because it depends on the terms of this particular policy, albeit, and I think I said this in answer to Lord Justice Popplewell, or indeed to you, my lord, there is a general rule of law which we say this policy does not, as it were, contract out of. So yes, strictly, you can't be bound by what has been said in relation to a different policy.
Well, I think my lord's point may be slightly different. The question of construction, you say, involves, as a matter of law, a presumptive construction, if I can put it that way. Is that a principle for which there's any binding authority, or are the passages you've shown us only dicta on that. I think that's really the point of the inquiry.
I think Lord Hobhouse's speech in Municipal Mutual is certainly dicta, the fire example, because it wasn't necessary to the decision. Those other passages are, statements of principle.
Yes.
In Wasser, Lord Mann said that the case could be resolved by seven propositions, of which this was the fourth. So if one takes out the fourth, one can assume that the fourth was necessary to his decision. So it's a statement of principle.
But that wasn't a case involving subsequent damage.
No, it wasn't. It was predominantly resolving damage that occurred decades before.
Prior damage.
Well, and also damage occurring as a result of the disposal of waste on many occasions over many years on many sites.
Yes.
So on the facts...
I don't want to hold you up, but that's not ratio in that case.
And of course, if one's talking about principles, I can't put it much better than the Chancellor did 2 weeks ago, in a judgment with which I think the two other...
Which I agreed.
Agreed.
You're entirely entitled
Without
to point that out.
of any part of it. But there we are. I move on quickly to ground 4, if I may, which concerns the judge's conclusion in paragraphs 90 to 94 that there was no cover under the policy for the costs of investigations, quote, save insofar as those investigations reveal physical damage that occurred during the period of insurance. Now, my lords, the point is significant because an important distinction between the Mace scheme and the insurer's scheme is that the Mace scheme involves what's called lifting the lid, which means opening up each compartment to allow the extent and the precise location of the damage within the roof to be ascertained, and also to work out precisely what form of repair is required. The Sky scheme, as it happens, is a mitigative scheme, which just involves replacing the roof with a metal or steel cassettes. So it doesn't arise in that context, but it's an important distinction between the Mace scheme and the insurer schemes. Two pieces of evidence, if I may, to start, and I'm going to, I'm afraid, in the interest of time, just give you the reference, certainly to the first. The first is something that Dr. Poole dealt with in his report. It's in Supplemental Bundle D, tab 45, pages 775 to 792. That is section 8 of his report, where he summarised the investigations that were carried out into the location of damage within the roof. And he describes the investigations carried out by somebody called Mr. Elliott of Mott MacDonald in 2020 and 2021, which involved opening up certain cassettes and creating a plan. And Dr. Poole goes on to discuss, and this is paragraph 8.4.1 of his report, page 785 of the bundle, on opening up reports that had identified damage in isolated cassettes upslope from the gutters, which we know were most badly affected. And there's a table in his report which records damage in areas associated with lifting strop holes and also roof lights. Now, those areas have been largely unsurveyed, but as Dr. Poole explains, and this is 8.5.5, a series of inspections were carried out in 2022 by Mr. Elliott, which involved opening up compartments containing lifting strop holes in 58 random cassettes. And the results of that exercise were that approximately 55% of the compartments containing lifting strop holes that were opened were likely to contain damage. So damage caused by water entering into or entering through the lifting strop holes due to the absence of a temporary roof. And Dr. Poole sets out his opinion that that sample exercise could be extrapolated to the entire roof. So the position is that whilst the gutter and the adjacent compartments were always known to contain extensive damage, a survey was carried out which indicated that there was likely to be damage in a very large number of locations elsewhere. And indeed, if you look at the judgment, paragraph 189, the judge accepted Sky's submission to that effect. Of course, precisely where damage was located and precisely what repair would be required, that would have to be determined by inspection. Now, the second piece of evidence is actually a passage in the cross-examination of insurer's wood science expert, Mr. Coulson. And again, in the interest of time, can I just give you the reference? He was being cross-examined by Mr. Reed. It's Supplemental Bundle E, tab 72B, page 1091. The cross-examination is at day 8 of the transcript, page 113, line 16 and onwards. He was being cross-examined by Mr. Reed, but it was actually an exchange between Mr. Coulson and the judge, His Honour Judge Pelling KC, where if you read it, Mr. Coulson accepted that the first thing you were going to do, if you were trying to work out where the damage was to open up the roof. I mean, the judge said, in order to work out whether a particular cassette requires replacing, repair, or requires no action at all, you must surely look at each cell within each cassette, mustn't you, as a bare minimum? Yes, my lord, of course, yes. Now, those two pieces of evidence are, so the recognition of the likelihood of damage elsewhere and the acceptance of a need to look at and open up each compartment. They are, we would say, a useful jumping off point for considering whether there is cover under the policy for the costs of investigation or lifting the lid. And we submit there are 3 reasons why there is cover for all of that and why the judge was wrong to reject it. My lord, the first reason is that there is no question at all here that there was extensive damage to the roof. Insurers submitted at the trial that the purpose of the proposed inspection was to investigate, quote, whether there is damage and whether there is a cause of action. Now, that's just not the case. There plainly has been damage here. Sky plainly has a cause of action against insurers for failing to hold it harmless. The purpose of the investigation is not to determine whether the roof has been damaged, but how extensive that damage is, where exactly it's located within the roof, and importantly, what is required by way of repair. Now, the judge, in rejecting the argument for coverage for investigation costs, he said, well, his conclusion was supported by the terms of the DE5 exclusion within the policy. But with respect to him, that point is misplaced. The DE5 exclusion excludes loss or damage to property insured caused to enable replacement, repair, or rectification of defective property. So, for example, access damage caused to facilitate the repair of something that was defective. We're not concerned with that here. What we're concerned about is investigations not to remedy defects, but to locate and to find damage in a roof which is known to be extensively damaged. So the point that insurers made about a speculative investigation designed to work out whether we've got a cause of action, it's just not right. The second point is in some ways related to the first. Insurers' point and the judge's point that any investigation is speculative and designed to see if damage has occurred. It only works if one considers each compartment of each cassette in isolation. So it only works if one can properly say, well, whilst one compartment of a cassette may be known to have been damaged, an investigation which involves opening up a different compartment in the same cassette or a compartment in another cassette to see if that's been damaged, that's all speculative and irrecoverable. But that approach, we would say, it ignores the evidence to the features of the cassettes and the nature of the damage. It's also commercially unrealistic. The cassettes were not entirely unique items. They had common construction features. For example, the 4 to 6 lifting strop holes that were present on each cassette to enable it to be lifted onto the roof. And so where damage has been found at a particular location in one cassette, water damage adjacent to a lifting strop hole, there is a real likelihood that the same sort of damage is going to be found in the same sort of location in another cassette. So the inspection is not speculative in that sense. It's also commercially unrealistic because without an inspection, it would leave Sky with a sort of patchwork quilt of repairs of a type that no sensible property owner would accept. I mean, repairs have been carried out in some areas of the roof, but even though it's known that it's quite likely there's damage elsewhere, those areas aren't going to be opened up and inspected. And indeed, insurers' argument is quite striking. Their own scheme, the 2018-19 scheme, involves work on 383 of the 428 cassettes on the roof, a very, very large number of the cassettes on the main roof, about 90%, 383 on, yes, 428, about 90%. What insurers object to is investigating the upslope compartments of cassettes, some of the compartments of which they're going to open up anyway in order to repair what's already known to exist. So it's an odd argument. You'll have seen that when giving my clients permission to appeal on this ground, Lord Justice Mayles remarked that it seems counterintuitive that the cost of carrying out a reasonable investigation to ascertain the extent of known damage should not be covered. He said it wouldn't make sense on the face of things to carry out a repair without first ascertaining the extent of the damage. We agree, it wouldn't make sense at all. I won't ask you to turn it up, but Lord Justice Mayles' intuitive reaction is actually similar to that Lord Justice Waller had in a case called Scandia property in Thames Water. It's in our authorities bundle at tab 22, page 344 of the authority. It also mirrors what Lord Justice Sheeman said in Yandenul versus AXA, which is a case on which the judge was addressed, where Lord Justice Sheeman spoke about the court's instinctive desire towards construing a policy in such a way as to permit the recovery of the costs of investigation.
Is this argument premised upon the basis that you're right on your first argument?
About continuing to no, because, and again, Mr. Windsor is going to come to this, there was evidence that at the time, at the end of the period of insurance, there was damage already at that stage in other areas. So it's not premised on any point about developing or continuing damage.
I mean, if you're right on your first, on the continuing damage argument, it does create a rather unusual situation if the insured, as it were, didn't dare open a cassette which at least appeared on the face of it, from the outside, to be undamaged, for fear of not being able to recover the costs of doing so. Because if you have to wait and see whether, as it were, it develops a swelling or a failure at some later stage, the actual damage that might be recoverable then would be all the greater. So it would be sort of counterintuitive. It would be sort of deterrent to somebody actually trying to figure out what the true extent was, to a point in time at which the actual damage, if recoverable from insurers on a continuing basis, would be greater.
Well, that is undoubtedly right. And there is, if I may say so, this oddity in the judge's decision. What the judge has decided is that there's no cover for the cost of investigations, quote, save insofar as those investigations revealed physical damage that occurred during the period of insurance. Well, you're only going to know that after you've done the exercise. But anyone sensible is going to want to know, well, are we covered for the costs of doing it if we open up?
But if the insurers are actually on the hook for the continuing,
yes, then the point may fall away.
Well,
depending on the points that Mr. Windsor is going to develop about it being reasonable to investigate upslope damage as opposed to gutter damage.
Yes, I mean, there might be questions as to whether the insured had acted reasonably in refraining from opening up if the result was going to be that damage would deteriorate. But if I'm right in relation to either ground 1 or ground 3, say there is cover for developing or continuous damage, then the case for covering investigative costs must be all the stronger.
Yes, that's the point I was trying.
Right. Well, I'm sorry, I've got there in a roundabout way.
I'm having a little bit of difficulty at the moment in seeing where this all goes. As I understand it, the investigative costs of lifting the lid have not been separately identified. You use this argument as a sort of step on the way. You say a step that gets you all the way. to the judge should have accepted the Mace or the Sky cheaper remedial scheme. But I understand you say, if what the judge was saying was, as a matter of policy construction, you can only get investigative costs if once you've done the investigation, it identifies damage which was in fact within the scope of cover. I understand your point that that's too narrow. If the point is, as I would presently approach it, that it's simply a question of what is reasonable mitigation, all investigative costs are designed to achieve a remediation scheme which reduces the damage that would occur if you did nothing. It seems to me a classic case of expenses in mitigation of damage, at which stage it simply becomes a question of was it or was it not reasonable to open up the lids to look at upslope damage on which there are no findings. Can we make any findings about that?
Well, I doubt this court can.
No.
It will have to be sent back. But in terms of the significance, it's significant for this reason, that the Mace scheme has been costed. And whilst I don't pretend to know the precise number that is attributable to opening up, the opening up exercise is a large number. So it is significant for that reason alone. The Sky scheme, as I've said, is put forward on the basis it's a cheaper way of mitigating the problem. But I'm entirely comfortable with the way, my lord, you put it, that if an inspection would be reasonable mitigation of what's occurred, then it must be recoverable.
I mean, in some circumstances, it may be reasonable to open up adjacent parts of a building to that where there's known damage. In others, it may not.
Well,
That's maybe what we're looking at in terms of gutter versus upslope.
Well, it may be, but the judge, as you'll appreciate, has just said no cover for investigation costs. Save, subject to the caveat. I'll make the third point I was going to make very briefly. I've made two already.
Just on that,
Yes.
there are strop holes in the up.
Yes. Usually 4 to 6, I think, per cassette, depending on exactly the nature of the cassette. So we're talking about strops that are used to lift the cassettes onto the roof. When the cassette's there and has been dropped into place, they're cut, they're severed.
Yeah.
But you get a gap which isn't sealed properly and water gets in.
Which may be on the upslope.
Yes, it may be on the upslopes, and that's, as I think tried to explain earlier on, although the majority of the water ingress has been into the gutter,
Gutters, there are some.
there are areas not in the gutter, not adjacent to the gutter, but upslope, where water damage has been found, and Mr. Winster's going to deal with that. And you're right, the judge didn't really make any findings in relation to that at all, and indeed appears to have assumed wrongly that the plenum, well, certainly parts of it, were encompassed in one of the schemes. Can I just make my third point, and then I'm afraid I'm going to have to sit down, because otherwise Mr. Winster will complain.
Yes.
I've said that the judge was wrong for two reasons, and I've given you those. The third reason is this. We would say that where there has been a physical alteration to or physical interference with property, and here what we're talking about is the unwanted ingress of water into the roof, the need for and the cost of a reasonable investigation by specialists can itself constitute an impairment to the value of the property, and thus the property can be regarded as physically damaged. Test it this way. Assume, hypothetically, that in July 2017, at the end of the period of insurance, Sky was contemplating selling Sky Central, and the building was being valued for that purpose. Entirely hypothetical, it didn't happen, but assume that was happening. Now, it is no more than obvious that the fact that the roof had suffered from substantial water ingress and that a comprehensive investigation would be required to work out the severity of the damage and the extent of that damage within the roof, that would have an impact on the value of the property. Perfectly obvious that would be the case. So we do actually say that if you have a physical change, a physical alteration to property, here water ingress into the roof, which requires a reasonable investigation by specialists, then that can itself constitute physical damage. Now, that proposition receives some support from the decision of this court in Yan de Nul, Again, in the interests of time, I won't take you to that, but the relevant passage for your note is in the judgment of Lord Justice Sheeman, and it's paragraphs 85 to 92 of his judgment. The authority itself is in your bundles, tab 28. Now, you'll see that the judge distinguished Jan de Nul on the basis that the policy in that case was in materially different terms, and he said, had used the phrase property damage where it was used in the policy in a wider sense than its literal one. Well, with respect to the judge and also with respect to Lord Justice Sheeman, it's not obvious that that is so, because the definition of property damage in the policy in Jan de Nul was property damage shall mean damage to destruction or loss of property excluding theft. And that's not materially wider than what the judge regarded as property damage in this case.
The decision is that investigation costs are property damage.
Property which is physically altered, where that alteration can reasonably require an investigation by specialists. The property can be regarded as damaged by reason of the need for investigation.
Yes, but the investigation costs are not themselves property damage, are they?
Well,
They're expenses incurred, reasonably incurred as a result of property damage.
if you're asking whether the property has been damaged, we'll come on to this, I suspect, on Thursday or Friday, but there are two basic criteria. One, has there been a physical change?
Yes.
The second, is it harmful in a commercial context?
Yes.
If you get over hurdle one, substantial water ingress into the roof,
Yes.
you ask yourself the question, is it harmful in a commercial context? If the answer is, well, you need to carry out a very expensive investigation to work out what the consequences of that water ingress is, that itself, we would say, involves harm in a commercial context.
Yes.
So the costs of investigation, the fact that you need to carry out an investigation and to incur the costs of doing so, the property can be regarded as damaged.
You said it equates to a diminution of value.
Well, it can do. As I say, assume the property needed to be sold and you valued it. Anybody looking is going to say, well, hang on, we know there's some damage. You haven't done a proper survey. You've got to go ahead and survey the whole lot. And until you do, we're going to take that into account in the price we pay.
But your case is, if you open them up and you find in some of them there isn't any damage, well, that's still a reasonable cost of investigation.
Correct.
But in that case, you wouldn't have any damage at all.
Well,
I just am not quite understanding how this adds to your other arguments.
right. Well, I think I've taken it as far as I can.
Yes,
I'm very conscious that I need to give...
We've interrupted you a lot. I've done very well with your time. Mr. Wilson.
My Lords, I am now going to address the remaining grounds in Sky's appeal, and I propose to take them in the following order, starting with ground 5, which is the finding of severe deterioration after the end of the period of insurance. Then secondly, I propose to address grounds 7 and 8 together. These both concern the judge's failure to make findings in respect of damage away from the gutters. I'm going to take ground 8 first, because that really explains the reason that ground 7 matters. And I think it's helpful to introduce ground 7 by reference to ground 8. And then, time permitting, I will also cover ground 9, which relates to the judge's failure to address the claimant's criticisms of the permanent works aspects of the insurer's remedial schemes. So starting with ground 5, I don't propose to ask your lordships to look at any of the authorities on appeals against findings of fact. I'm sure the tests are very well known to the court. Perhaps if I could just summarise what we say is wrong with the judge's finding of severe deterioration. We say really it suffers from 3 flaws. The first is that so far as it is a finding of primary fact, it is, quotation marks, plainly wrong. That's the expression used in the authorities. There are a number of ways in which the plainly wrong test has been explained or expanded upon, and one of those is that it's a conclusion which the evidence cannot on any view support. and that's, I think, the most apposite. If authority is needed for that, it's found in Lady Justice Carr's judgment in Walter, Lilly and Klin at paragraph 85, Roman 1. That's tab 67 of the authorities bundle. The second flaw is that so far as this was an evaluative decision, i.e. a judgment as to the extent or severity of deterioration, it's inconsistent with other findings in a way that undermines its cogency. And again, authority from that can be found in the same case, Walter, Lilly and Klin, at paragraph 86. And then the third difficulty is that it is entirely unexplained. The judge failed to give any reasons for this finding, and the authorities establish, unsurprisingly, that a judgment has to make clear, both to the parties and to an appellate court, the judge's reasons for the conclusions on the critical issues. One way that was put is by Lord Phillips in English and Emery Reinbold, which is tab 27 of the authorities. At paragraph 21, Lord Phillips said, "The essential requirement is that the terms of the judgment should enable the parties and any appellate tribunal readily to analyse the reasoning that was essential to the judge's decision." And there simply isn't any reasoning which allows either the parties or this court to do that. So, Lord, the position at trial, and to some extent I need to go back over ground that Mr. Edwards covered in his introduction, but it is necessary to do so. At trial, it was common ground that the roof had suffered extensive damage as a result of water ingress. The difference between the parties was when and how the damage had occurred. And that depended in particular on when and how the water got into the roof. And there were two competing theories as to when and how the water got in. The claimant's theory, which was based on the evidence of Dr. Poole, a material scientist, was that the overwhelming majority of the water ingress occurred during construction as a result of a systemic vulnerability around the edges of the Derbigum on each of the cassettes. That vulnerability only existed in the temporary condition because the edges were then covered by cap sheets in the permanent condition, so that water could no longer enter once the construction was complete. And there were 3 points of water entry. The most significant one was at the gutter upstands, and Mr. Edwards showed you Dr. Poole's mock-up of the 90-degree bend between the gutter floor and the gutter upstand, which was the point at which the majority of the water entered. And the reason that most of the water entered there is fairly self-evident. Although notionally flat, the cassettes are in fact slightly angled down towards the gutters, so rain will naturally collect in the gutters, and the gutters are flat, they work on a siphonic drainage system, and so they have a head of water standing in them. So there would be, and there were, significant amounts of water that both ended up in the gutters and stayed there. But in addition to that primary route of entry, Dr. Poole identified 2 subsidiary routes of entry upslope. Firstly at the lifting strop holes, and secondly at the roof light upstands. And I'll cover those in a little more detail when I come on to grounds 7 and 8. So whilst the overwhelming majority of the water entered during construction, there were a handful of instances of post-construction water ingress. But the majority of those were at vent housings, which were installed as part of the remedial drying works carried out in 2018 to 2019. And those instances of post-construction water ingress were not causatively significant. for two reasons. Firstly, they were infrequent in number. They affected individual compartments in at most 14 cassettes out of the 472 on the roof. And they had no significant consequences. So the compartments in which the vents were installed were no longer the encapsulated bathtub that Mr. Edwards explained. After the vent was installed, they were ventilated. So any water that entered at the vent was able to dry naturally. So the condition of those cassettes or those compartments was fundamentally different from the position it had been in previously. And there were, on the evidence, only about 5 compartments out of about 5,000 in the roof in which there was no vent, so they were still encapsulated, and in which there was post-construction water ingress. So, in other words, Dr. Poole's theory was that the water got in during construction, and there was no water ingress post-construction that was of any causative significance. And I should probably emphasize that when I talk about causative significance, what I mean is water that would cause damage, which in turn would have a material impact on the complexity, scale, and ultimately the cost of the remedial scheme, because anything short of that simply doesn't matter. So that was the claimant's theory, Dr. Poole's theory. By contrast, insurers' theory, which was based on the evidence of their expert, Mr. Jessup, a structural engineer, was that water entered the cassettes through a multiplicity of imperfections in the Derbigum. The judge described it at paragraph 159 of the judgment as, and I quote, a myriad of different workmanship failings occurring at random times and places after as well as before installation of the permanent waterproofing. So his theory, which was insurer's case, was that water ingress occurred both during construction and after practical completion and after the end of the period of insurance. His theory was that water ingress and water damage was much more extensive by the time of the trial than it had been either at the end of the period of insurance or on completion of the drying works in 2019. His theory depended upon there being significant, ongoing, post-construction water ingress. The narrative that insurers advanced at trial, namely that the Sky and Mace remedial schemes are intended to address much wider damage than existed at the end of the period of insurance, was necessarily based upon Mr. Jessup's causation theory. And that narrative is irreconcilable with Dr. Poole's competing theory, on which the claimant's position was based. In other words, that the extent of damage at trial was essentially the same as it had been at the end of the period of insurance. And whilst there had been some deterioration, it was not to the extent that it had any material impact on the cost or scope of the remedial work that was required. Now, the judge preferred Dr. Poole's evidence to that of Mr. Jessup, and so he accepted the claimant's case on causation, and he rejected Mr. Jessup's competing theory in unequivocal terms. And that's apparent from a number of paragraphs in the judgment, particularly paragraphs 168. If Lordships would like to look at this, it's Core Bundle B, tab 15A, page 414. So paragraph 168, one sees that the judge there is dealing with Mr. Jessop's myriad of workmanship errors, and he says in the penultimate sentence, there is no evidence that any one or more of them were a cause of water ingress. They were, as Sky put it in their closing submissions, theoretical possibilities. And then over the page at paragraph 170, the judge says, in summary, therefore, I reject Mr. Jessop's analysis of the cause of water ingress during the relevant period. I do so because I found Dr. Poole's explanation much the more convincing, and I accept his evidence on these issues. In paragraph 171, 8 lines down, the judge describes Mr. Jessop's lap theory as being an untested and unproved hypothesis. And if I could ask you to turn over the page to 416, one sees at paragraph 173, the judge held that Mr. Jessop's explanation was implausible for at least the following reasons, and he sets out 3. The first, at paragraph 174, is that Mr. Jessop was not able to identify any specific instance where ingress into a cassette was caused by the route he suggested. Second reason, at paragraph 175, the judge found it inherently unlikely that water would enter the cassette in this manner, but if it did, and this is quite important, you can see there that the judge accepted Dr. Poole's evidence that it would be an insignificant amount. And then the third reason is over the page at paragraph 176, where the judge says the pattern of damage is not consistent with penetration occurring in the way described by Mr. Jessop. My lords, there is no appeal against any of those findings. It's important to note that the 2 competing causation theories each sought to explain the entirety of the water ingress, and thus the entirety of the damage, without any form of temporal limitation. And they were expert investigations and theories developed wholly independently of legal questions such as the period of insurance or the meaning of damage. The judge's acceptance of Dr. Poole's theory and his rejection of Mr. Jessop's theory, as I said, meant that there were only individual compartments in a maximum of 14 cassettes into which there was post-construction water ingress. And we can see that from what the judge says in paragraph 175, that the 175 actually is sort of split into several paragraphs, but the final one on page 416, he says he was willing, he's referring there to Dr. Poole, he was willing to accept that this had, to his knowledge and from his investigations, occurred only on 4 occasions to 4 cassettes. So those are 4 cassettes which Dr. Poole accepted had later water ingress. Mr. Jessop relied on many more, but the common theme of his supplemental report is that these occurred after the period that I considered to be the relevant period, largely in a period between March 2020 and April 2022, after the drying out work in 2018 to 19, and it is accepted that the damage caused by water ingress during the period of insurance was brought to an end. And he explains that these concerned patch repairs and vent housings, and all post-dated the end of the period of insurance. Now, the many more, the judge doesn't spell out how many it is, but it is up to 14 cassettes that were affected by this. Now, the judge's finding that there was severe deterioration in the roof after the end of the period of insurance is found in 2 paragraphs of the judgment, notably in the quantum section.
I'm just, forgive me for being a bit slow. So what's being said at the bottom of the page, 175, is that the difference between Dr. Poole's 4 cassettes and Mr. Jessop's, much more extensive, is that Mr. Jessop's occurred outside the contract period and after the 2018-19 drying out works. Is that right?
Yes.
Or have I misread that?
I can quite see why Your Lordship reads it that way. It isn't perhaps as clearly expressed as it might be, but the reference to those that Mr. Jessop is relying on is a reference to instances set out in Mr. Jessop's second report based on his review of later opening up and later investigations. And he sets out there a view that there was later, as in post-construction, indeed post-2019, water ingress into a number of cassettes. And if you correlate those with the ones that Dr. Poole himself identified, you get in total 14 discrete cassettes. And as the judge notes, they are mainly concerned with patch repairs or vent housings. The vast majority are vent housings. Some are patch repairs, and there are a couple which are unexplained.
But you say if you correlate them, is the judge there rejecting Mr. Jessop's evidence that they occurred, albeit occurred after the drying out works?
No, I think he's accepting it.
So your 14 are Mr. Jessop's, not Dr. Poole's, are they?
Cumulative, it's 14.
It's 14 for both of them?
Yes.
I see. When you say correlate them, Poole plus Jessop?
Poole plus Jessop equals 14.
I see, thank you.
Of which about 5 are not unventilated compartments.
I understand, thank you.
So, my Lord, the judge's finding of severe deterioration is not in the causation or damage part of the judgment. It's in the quantum part of the judgment. If I could ask you to turn on to page 420, you'll see above paragraph 182 there's a heading quantum, and the finding of deterioration is in 2 paragraphs. It's in paragraph 183, and it's in parenthesis, 4 to 5 or 4 to 6 lines down in that paragraph. The judge says the state of the roof is now much worse than it was at the end of the period of insurance, and so requires significantly more work than is contemplated by the defendant's schemes. And then a similar statement appears if you go on to page 436 in paragraph 224. Second sentence there, the judge says, that was all but inevitable once it is accepted that the roof has suffered further severe deterioration after the end of the period of insurance and after the drying out works. It is now accepted would have arrested the deterioration resulting from water ingress occurring down to the end of the, he says policy of insurance, I think it means period of insurance. As I said earlier, there is no reasoning or basis set out in the judgment for these findings.
Those are 2 separate things. One is 183 covers the period between 2017 and the end of the drying out works. It's just post POI. Whereas 224 seems to be post drying out works.
No, that's right. It's more specific as to timing.
I think it's common ground that there was some deterioration between end of the period of insurance and the 2018-2019 drying out works.
No, that's correct. Yes.
Whether or not that's categorised as severe may not matter very much in the light of the judge's finding that it didn't make any difference to the cost.
Quite. But what does matter is...
So it's 224 really that matters?
Yes. Yes, the judge has, or appears to have been under the impression that there was further severe deterioration after 2019. And that as he has effectively set the remedial scheme by reference to the position in 2019, that is significant. And this is one of the factors that seems to have led him to discount the Mace scheme. He was under the impression that it addressed a far greater scope of damage than existed after the drying out works in 2019, because, so he thought, there was further severe deterioration. My Lord, when Lord Justice Mayles gave permission to appeal on this ground, he observed that this finding was at least arguably inconsistent with other findings made by the judge. And in our submission, there are indeed fundamental inconsistencies. The judge found that the drying out works in 2018 to 19 were effective in arresting any further decay. That's at paragraphs 136 and 154 of the judgment. He also found that there was probably, quote, some additional deterioration, end quote, between the end of the period of insurance, i.e. July 2017, and the completion of the 2018-19 drying out works, as Lord Justice Popplewell just referred to. That's paragraph 156. And he went on to find, paragraph 157, that that deterioration would not alter the type, scale, or cost of the remedial work required. And there's no challenge to any of those findings. Insurers sought to challenge the third of those findings. That was the subject of their ground 3,
Yes.
For which permission was refused. The fact that insurers can't go behind that finding is, we say, significant. It means that both their 2017 remedial scheme and the exercise carried out by their wood science expert, Mr. Coulson, looking at photographs taken later and trying to extrapolate backwards to the position in 2017, can be ignored. They're simply not relevant, because what matters on the judge's unchallenged findings is the state of the roof in 2019 at the completion of the successful drying out works. So as at 2019, the position on the evidence and on the judge's findings was as follows. Firstly, the progression of the decay had been arrested. For there to have been any deterioration in the condition of the roof after 2019, it would have been necessary for there to have been further water ingress after 2019. And that's a point the judge explicitly recognised in paragraph 136. He said, in the interest of time, I'll just read the 2 sentences that matter. Ultimately, both wood science experts were agreed that the drying out work that occurred in 2018 to 19 arrested any further decay. It is likely, therefore, that any damage that occurred thereafter was caused by water ingress that occurred after those works had been completed. So the judge made that finding, and as a matter of logic, that is, of course, correct. And the judge made no finding of any significant water ingress into any part of the roof after construction. The evidence wouldn't have justified a finding of any post-construction water ingress of any causative significance. As I've said, there were at most 14 cassettes in which individual compartments had post-construction water ingress. The majority of those were due to leaks around vents, which were installed to facilitate remedial drying. And at that point, that the majority were at vents, was accepted by Mr. Jessup in cross-examination. I can just give you the reference. That's the transcript from day 10, page 59, lines 5 to 17, which is at supplemental bundle E tab 74B, page 1112. And as I've said, water ingress into those vented compartments is of no causative significance because they're vented and that water can dry naturally. That is confirmed, if I could give you 3 references to the evidence. Mr. Wellesley Smith's first report, paragraph 10.1.8, which is supplemental B, tab 40, page 523. Dr. Poole's first report, paragraph 6.11.3, which is supplemental D, tab 45, page 771. And by Dr. Poole's evidence in cross-examination, transcript day 9, page 23, line 20 to page 24, line 13, which is supplemental E, tab 73C, page 1100. Just worth noting that, as Mr. Edwards explained, the process for drying out was a hole was cut, the insulation was removed, and a vent was put in, and air was blown. Those vents haven't been removed, they're still there today. It means that those compartments don't have any insulation in them. So any water that gets in, has got in subsequently through the vent or round the base of the vent, doesn't have any immediate damaging effect on insulation because there is no insulation in there. So the only potential effect it could have would be damage to timber. As I said, because they're ventilated, that doesn't pose the problem that water entry into unventilated compartments.
Are these all in the gutter sections or any on the upslopes?
They are all in the gutter or immediately adjacent sections. I think the most they ever extend is perhaps 2 compartments up from the gutter. There are none near the apex of any of the cassettes.
Thank you.
Now, the reference to patch repairs is to gutter and immediately adjacent compartments which were opened in 2018-19 and found not to have problematic moisture levels. So rather than having a vent installed, they were simply resealed. So again, it's not upslope, it's all in the areas of the gutters. Now, I accept that in principle, water that gets in at those could be instances of new damage, but they are so infrequent in number that they cannot be causatively significant. As I said, it's 5 compartments out of a total of 5,000 or so on the roof. Now, insurers make the point that the judge's finding that the 2018 to 19 drying out works arrested decay must necessarily only relate to the bays or compartments which were in fact dried out. Now, it's true that the drying out works were limited on the main roof level to the gutters and immediately adjacent bays. But this doesn't in any way undermine our arguments on this ground for 2 reasons. Firstly, as I'll come on to on ground 7, the judge failed to make any findings about upslope damage.
Sorry, so what was dried out and what wasn't dried out in the 2018-19 works?
The focus was very much on the gutters,
Yes.
and in some instances the immediately adjoining upslope bay or compartment.
And was it all the cassettes?
I think every cassette was opened and the moisture level was investigated. When it was found to be above the trigger level, then the insulation, wet insulation, was taken out, vent was installed, and dry, warm air was blown in until the moisture level was reduced below the trigger level. Where it wasn't problematic, it was simply resealed. But yes, those works were limited to the gutters and in some instances immediately uphill bays. They did not extend anywhere near to the apex.
Thank you.
So I was saying there are 2 reasons why that doesn't undermine our argument on this. The first is the judge hasn't made any findings at all about upslope damage. So there are no findings as to the location, extent, timing, or cause of upslope damage. There's no starting or ending point for any deterioration. There's no baseline from which that could have deteriorated because there's simply no finding. We respectfully submit that a finding of deterioration in a factual vacuum is meaningless. The second point is that for there to have been severe deterioration in the upslope areas after 2019, there would have to have been further water ingress into the upslope areas after 2019. As I've said, the evidence of post-construction post-2019 water ingress was very limited, maximum of compartments in 14 cassettes, most of which are at vents and patch repairs, which are near the gutters. So there was no evidence of any, certainly no significant water entry upslope after 2019. And furthermore, it's important to note that the upslope areas were only opened up, investigated in 2022. And by the time they were opened up, they were found to be dry, albeit to have sustained damage. And the reason that they were dry and yet damaged is because the mechanism of water entry, essentially the roof light, upstand, and lifting strop hole, allowed far smaller quantities of water to get in than was able to get in by the 90-degree bend in the gutter, because it's at the bottom of the slope and has the standing water and so on. Whilst that water that entered at the gutters was far too large in volume to naturally dry out, the smaller quantity that entered upslope was able, in the period of sort of 5 to 7 years between construction and opening up, to dissipate naturally throughout the cassette. And this comes back to a point that was raised during Mr. Edwards' submissions about the hermetic sealing and the encapsulation. If you have a relatively small amount of water in the cassette, given time, it will spread, naturally dissipate throughout that cassette. It can't escape the cassette, but it can, as it were, reach an equilibrium within the cassette. And the expert evidence was that that's what happened. There was natural dissipation, which explained why, when these locations were opened up, they were found to be dry, but to have sustained damage. And Dr. Poole's explanation for this dissipation is found at paragraph 9.5.3 of his first report, which is Supplemental Bundle D, tab 45, pages 807 to 808. So on the evidence, there simply was no basis for a finding of severe deterioration. And the judge's finding of severe deterioration was directly contrary to the cases advanced by both Sky and Mace. Perhaps if I could ask you to turn to Supplemental Bundle A, tab 11. What you will find when you get there is Sky's note to the judge, which was submitted during the course of the oral closing submissions at the end of trial. And this most pithily sets out what Sky's case was. If I could ask you to look, please, on page 198, the top of the page, paragraph 1E. In the present case, any deterioration of policy period damage in the gutters and eaves compartments after policy expiry was arrested by effective drying out works in 2018 to 19. And then at F, a contrast is drawn between the ascertainment of the full extent of insured damage.
So it's my fault, I'm not with you. Where are you?
I'm sorry, bundle page 198.
Oh, so I've got you. Thank you.
I was looking at paragraph 1E at the top,
Yeah.
and moving on to paragraph 1F, which draws a contrast between damage and ascertainment of damage. And then, if you look at page 199, paragraph 2C, Sky submits that there are discounting the insurer's 2017 scheme, both insurer's 2018-19 scheme and the Mace scheme are broadly based on damage which existed as at 2018 to 19 because, and then 4 points are set out. Firstly, all the experts agreed the 2018-19 drying works in gutters and eaves were successful and arrested further deterioration. Secondly, the more limited upslope damage found in 2022 had already dried out naturally by 2018-19 because of dissipation. The water that entered was a much smaller quantity. Third point, as a result, the actual damage as at 2018-19 and the damage as at 2022 to 23 is substantially the same. That, if I could just draw you finally your attention to letter E at the bottom, it is accepted that existing damage from July 2017 may have been subject to some limited deterioration until 2018-19. The claimant's case is that there was no new damage. Such deterioration would not alter the type, scale, or cost of the remedial scheme. So that was the way Sky's case was put. And the judge accepted the majority of those points. He preferred Dr. Poole's theory on causation of water ingress. He rejected Mr. Jessop's competing theory. But somehow, and unexplained, the judge reached the conclusion that there was severe deterioration after the end of the period of insurance. Try as I have to work out how the judge may have reached this view, he appears to have accepted a submission made by the insurers. If I could ask you to go into supplemental bundle E, which contains the transcripts. And towards the end, there's tab 81. That's 81A, please. This is bundle page 1145. And my lord, the bottom left of the 4 transcript pages, so page 34, you'll see this is Mr. Rigney's closing submissions after the trial. At line 2, the end, he says, on the claimant's own evidence and on their own case, there was very significant deterioration after 2017. Well, that submission, we say, is fundamentally wrong. The claimant's evidence and the claimant's case was the very reverse of that. Namely, that whilst there was some deterioration between 2017 and 2018 to 19, it was of no causative significance. And the judge accepted that. If we look further down the page at the two examples were given by insurers in support of that submission. The first we see at lines 6 to 13, which was to invite the judge to compare insurers' 2017 scheme with their 2018-19 scheme. Well, with the greatest respect, that's obviously a self-serving comparison. At its highest, that might show that on insurers' view, there was significant deterioration between 2017 and 2018-19. But that was a point the judge explicitly rejected. He held that insurers' 2017 scheme was based on too restrictive a view of what constituted damage. And he also held that any deterioration between 2017 and 2018-19 was causatively irrelevant, as it didn't affect, ultimately, the cost of repair. So that justification falls away. The second justification appears at lines 16 to 20, where the judge was invited to compare Mr. Elliott's RAG plan, that's a red, amber, green plan of damage on the roof, with Mr. Coulson's damage map. Now, it's true that Mr. Coulson, insurers' experts, attempt to retrospectively work out the state of the roof in 2017, working back from photographs taken 2018, 19, and later, results in a narrower scope of damage. But that exercise was rejected by the judge as not being appropriate. Well, for two reasons. Firstly, he applied the wrong test of damage, and secondly, the photographic record was incomplete. So again, that justification goes nowhere. Final point I just need to address on this ground is insurers' contention at paragraph 48 of their skeleton that there was ample evidence for the judge's finding of severe deterioration after the end of the period of insurance. They make 4 points in an attempt to justify the judge's conclusion. The first is to take issue with Sky's interpretation of paragraph 175 of the judgment. That's the paragraph we looked at earlier.
Give me the paragraph of the insurer's skeleton you're addressing.
Yes, 48. So the bundle reference is 4A, tab 8, page 227. So at 48.1, you'll see insurers' first point is they say the judge did not determine there was water ingress to only 14 cassettes after the 2018-19 drying out works. Well, there's no need to debate whether the judge made that finding or not. That is what the evidence combined of both causation experts identified. And insurers, certainly as I read their skeleton, do not contend otherwise. They do make a point based on Mr. Coulson's evidence, but I'll address that in a moment. The second point they make at 48.2, they say that the judge accepted Mr. Jessop's evidence that water was able to enter the cassettes through patch repairs and vent housings after the period of insurance and between 2020 and 2022, and they dispute that such damage was shown to be minor and localized. Well, as I've said, it's common ground that there was some post-construction water ingress. Cumulatively, on the basis of both experts, it was affecting compartments in up to 14 cassettes. As I've said, the majority were vent housings which were able to dry out because they were now naturally ventilated, and at most there were 5 unvented compartments with post-construction, post-2019 water ingress. And it can't seriously be suggested that 5 compartments out of 5,000 is causatively significant. The third point they make is in relation to Mr. Coulson. They say that he gave evidence of water ingress and deterioration after 2019. In respect of deterioration after 2019, insurers rely on one answer Mr. Coulson gave in cross-examination in respect of figure 26 in an appendix to Mr. Smith's report. Mr. Coulson was referring to a single piece of wood in the gutter compartment of cassette 154. On Mr. Coulson's own damage map, he considered that compartment to be inconclusive as to whether it was damaged or not in 2017. Reference for that is Core Bundle B, tab 22, page 626. Mr. Jessop's assessment of that compartment, based on his assessment of the position in 2018 to 19, it's marked red on his plan, which indicates it requires full replacement of the bay. We see that at Core Bundle B, tab 22, page 616. So that offers no support for the judge's finding of severe deterioration. That bay already required complete replacement, as at 2018 to 19, even on insurer's own case. The second part of this, Mr. Coulson's evidence of 48 bays with water ingress after 2019. Well, the first point is that water ingress wasn't a matter for Mr. Coulson. It was a matter for the causation experts. The judge expressed himself to be less sanguine about Mr. Coulson's evidence on water ingress. That's at paragraph 150 of the judgment. And in any event, Mr. Coulson's view is inconsistent with the judge's rejection of the Jessop theory of water ingress and his acceptance of Dr. Poole's explanation. It's also worth noting that Mr. Coulson was extraordinarily dismissive of the moisture readings that were taken. Whilst he had explanations for how artificially high moisture readings could be taken by inappropriate use of the equipment, he didn't have any explanation for how you could get falsely low readings. And as I've said, these compartments, when opened up, were found to contain low moisture levels. And we submit that it's most unlikely that the judge would have preferred Mr. Coulson's subjective impression of recent wetness from looking at a photograph to the objective evidence of professionally taken moisture readings, which showed low moisture content. And then, my lords, over the page at 48.4 is insurer's fourth point. They observe that the judge's finding about the drying out works having arrested decay can relate only to the bays that were dried out. Well, I've already addressed this. It's true, but that is no answer to our arguments on ground 5. My lord, with that, I'd like to move, if I may, to ground 8. So ground 8, I'm going to cover before ground 7, because it's the explanation of why the judge's failure to make findings about upslope damage is important. And the key point is a simple one. Insurers' remedial schemes do not address any damage away from the gutters. And they don't include any remedial work to the plenums. That ought to be uncontroversial. It's readily apparent from the summary plan of their 2018-19 scheme at Core Bundle B, tab 22, page 616. The judge failed to appreciate this. And we know that because it's apparent from what the judge said in his second post-judgment ruling when refusing permission to appeal. If I could ask you to look at that in Core Bundle B. Tab 15C. And it's bundle page 466.
Got there in the end.
Grateful, my lord. You'll see there's a heading above paragraph 37, Mace's application. The judge dealt first with Mace's application for permission to appeal. There were then, as there are now, some common grounds. And the judge in paragraph 37 is addressing Mace grounds 1 and 3 and then 2. And if I could draw your attention to 5 lines down, there's a sentence which says, to the extent plenums are relevant at all, they come within that scheme. That's referring to Defendants' 2018-19 scheme. And the contrary was not suggested. It was not suggested by Mace that the 2018-19 scheme was deficient by reference to the plenum issue. I'm afraid the judge was wrong on both counts, that the plenums do not come within either of insurers' schemes. And this was one of the criticisms advanced by both Sky and Mace, clearly and repeatedly. All of the insurers' experts made it clear they had omitted plenums from their consideration. For example, that's at Mr. Coulson's first report, paragraph 11.1, Mr. Jessop's first remediation report, paragraph 3.7, and paragraphs 5.12 to 5.15. And again, Mr. Jessop confirmed in cross-examination that he had not considered the plenums or provided any repair proposals for them. And the reference for that is transcript date 12, page 1, lines 8 to 14, which is supplemental E, tab 76C, page 1123. Sky made the point in its submissions that insurers' schemes failed to address the plenums or upslope damage. It was made clear in Sky's written opening, paragraph 264, subparagraph 3. It was made clear in Sky's written closings, paragraph 153, which is at supplemental A, tab 8E, page 105. And it was also made in Sky's note to the judge, to which I took your lordships a moment ago. Reference for that is paragraph 2, Roman 1, subparagraph 3, supplemental A, tab 11, page 201. And the point was also made by Mace. Insurers make no attempt to justify the judge's misapprehension as to the scope of insurers' schemes. Indeed, they barely address Sky's ground 8 at all in their respondent's skeleton. They appear to contend that the judge's misapprehension doesn't justify a departure from insurers' schemes. We say that's an ambitious submission for them to make because it amounts to accepting that there's a demonstrable flaw in the judge's reasoning, but asking this court to conclude that it would have made no difference if the judge hadn't been under that misapprehension. And we respectfully say that's simply not realistic to invite this court to do that. It has to go back to the judge to be corrected and for him to reassess the position, appreciating what was and wasn't included. So, my lord, that leads me into ground 7, which is the judge's failure to make findings about damage away from the gutters. Sky's case was set out in its written opening, paragraphs 249 to 262. It's in the bundle at Supplemental A, tab 5H, pages 39 to 41. I won't ask you to go there given the time, but in summary, what Sky submitted was that insurer's position assumed that the only material damage was in or adjacent to the gutters, that was not correct, as the investigations in 2022 had revealed, and that in fact there was widespread damage upslope and remote from the gutters. And importantly, at paragraph 257, Sky submitted that the court should reach its conclusions based on a combination of evidence from investigations, expert evidence as to the proper inferences to be drawn from those investigations, and extrapolation based on inherent probabilities. And you've heard about lifting the lid. Lifting the lid is the only way to ascertain the full extent of this damage. And lifting the lid is in itself an enormous operation, which, to do safely, requires some form of temporary cover for it to be completed under. Otherwise, you expose these cassettes to exactly the problem that occurred during construction, which is further water ingress. So if I can address then the sub-parts of ground 7, the specific items on which there are no findings. The first is plenums. Plenums are the areas of the roof around the 6 cores. They're on a higher level than the main roof level. There are a total of 44 plenum cassettes, so they account for nearly 10% of the total cassettes on the roof. So they're not an insignificant number. And in fact, they're more important than that simple mathematical representation would suggest, because the fact that they're on a different level means that they are inherently more difficult to access and to remediate. And worse still, about half of them are obstructed by large pipework for the building's heating and cooling systems, which is the reason that about half of them haven't yet been investigated. They cannot be investigated because they are not accessible. So they have a significant impact on the complexity and cost of remediation. And insurers' remedial schemes make no attempt to do anything for the plenums. Within the judgment, there is no reference to the plenums at all. The judge appears to have completely overlooked them. Worse still, as I've explained, and as we saw from his refusal of the application for permission to appeal, he appears to have been under the misapprehension that insurers' schemes address the plenums, when in fact they don't. Insurers say that there are 4 obstacles to damage to plenums being recoverable. We see this in their respondent skeleton in the Mace appeal, which is Core Bundle A, tab 10, page 270. You'll see right at the bottom of page 270, Mace's submission that damage to plenums was recoverable faces the following obstacles. And then over on 271, they set out the 4 obstacles. Firstly, they say no witness had given evidence as to any water or water damage being seen in the plenum cassettes at any time. Secondly, no inspection of any plenum cassettes took place until March 2021. Thirdly, half of them have not been inspected at all. And fourthly, no photographs were available of any damage to plenums, so expert retrospective analysis was not possible. Well, except that point 3 is correct, because of the pipework I referred to a moment ago, each of those points are demonstrably wrong. Mr. Hamblin of Mace, a factual witness, gave evidence of drying out works to the accessible plenums undertaken in the week of the 22nd of April 2019. That's paragraph 50 of his first witness statement, which is supplemental A, tab 32, page 316. Obviously enough, there would be no need for drying out works if there hadn't been water ingress. There was also contemporaneous documentary and photographic evidence. And if I could ask you to go back into supplemental bundle A, please. And go to tab 24. You should have there an email from Mr. Hamlin of Mace, dated the 8th of June 2019. The subject, Sky Plenum Cassettes, and it's addressed to someone called Andy within Mace. Although we had to abort the planned opening up of the main roof cassettes, we did manage to open up a section of the plenum roof cassette on core 6, where there is a soft spot in the roof deck. I've attached some photos of what we found. Prater took moisture readings of the timbers and found moisture content to be high, circa 38% at top of timber, mid-20s lower down. He refers to degradation to timber, mould growth. The conditions were similar to what we had found before on the main roof. The cassettes at this level do not have any gutters. And then the photographs one sees behind the email. And they run through to page 281. So there was witness evidence in respect of the plenums. There were inspections of the plenums in 2019, both in April and in June, and there were photographs of the plenums. There was also a RAG plan, red, amber, green plan, specifically of the plenums. I think it is worth asking you to turn that up. It's in supplemental bundle C. That's tab 41F, F for Foxtrot. Page 677. I think this may be one that you have in A3.
Sadly not in my bundle, but I do.
If you only have the A4 version, the point is the same. You can see...
So whose rag map is this? Is this one on Mr. Mott's?
So this was produced by Mr. Elliott of Mott MacDonald.
Sorry, Mr. Elliott.
Yes, who was an independent engineer engaged by Sky to investigate the roof. This was exhibited to Mr. Wellesley Smith's report. So this is actually Appendix K to Mr. Wellesley Smith's supplemental report. So the RAG plans were prepared iteratively. I think the first one was produced in January 2020, and they were regularly revised as inspections revealed more information about the roof. But you can see what we're concerned with is red areas showing damage, and you can see on this the plenum cassettes which are obstructed by pipework. You can see the sort of grey pipework obstructing about half of the cassettes, and you can see significant areas of red. By my count, that there is.
So which are the plenums?
So you can see the yellow things called cores,
Yes.
and the plenums are the cassettes around the edge of the core. So each cores, the four lower cores, 5, 2, 6, and 3, have 8 cassettes, 8 roof cassettes going around them. They're different to the main roof cassettes. You can see that they have a sort of mitre joint in the corner. And rather than having a fall along their length, they have a fall across their width. By my count, there are red areas signifying damage in 21 of the 44 cassettes. And of course, many of them are obstructed by the pipework. Now, the claimant's wood science expert, Mr. Wellesley Smith, expressed confidence that these plenum RAG plans represented the most accurate assessment of the extent of damage as revealed by inspections of the accessible areas to date. And he also expressed the view that it was highly likely that that damage occurred prior to July 2017. The reference for that is Mr. Smith's second supplemental report, paragraphs 4.2.1 and 4.3.3, which is supplemental B, tab 41A, pages 576 to 578. And my lords, there was no competing expert evidence to challenge that, because the insurer's experts did not consider the plenums. So we say there was no basis on which the judge could properly have rejected the claimant's unchallenged evidence as to plenum damage, and his failure to make any findings on plenum damage was a failure to deal with a material aspect of the claimant's case. Now, my lord, I appreciate that time is running out. I obviously do have more to cover, but the next topic would be lifting strop holes.
How long do you think that's going to take you?
If I compress it as much as I can probably do them in about 5 minutes.
Why don't you do that?
I'm very grateful. Lifting strop holes came up this morning, and perhaps this afternoon, in discussions with Mr. Edwards. Each of the cassettes has lifting strop holes. Most of them have 6. The shorter cassettes that abut the cores only have 4. You saw the photograph of where they are located. They are, as you might expect, to facilitate lifting. So they are spaced along both of the long sides of the cassette. The judge appreciated that it was part of the claimant's case that water entered the cassettes at these lifting strop holes. That's plain from paragraphs 16, 137, and 159 of the judgment. And indeed, it was the discovery of upslope damage at both lifting strop holes and the roof light upstands that led Mace to expand its remedial scheme to include lifting the lid, because that was what revealed that the damage was not limited to the gutters and adjacent bays as had previously been thought. And you see that most clearly in Mace's Stage 3 addendum from October 2022, which is at Supplemental A, tab 26, page 284. There was also witness evidence of damage at lifting strop locations. Mr. Elliott of Mock MacDonald gave evidence in paragraph 21 of his statement, which is Supplemental A, tab 33, page 322. In summary, he said that in February to April 2022, lifting strop compartments above the green line, that was the line at which Mace thought there had not been any further damage upslope, were opened in 60 compartments, and about 50% of those were found to contain damage. It was common ground between the causation experts that water had entered the roof at lifting strop holes. One sees that in the causation joint statement, Supplemental E, tab 51, page 852. It's in tabular form, but they're the experts' opinions at paragraph 1.1 on that page. There is agreement that water entered at the location of lifting strop holes. Dr. Poole gave evidence as to the extent of damage at lifting strop holes. In two respects, he gave evidence of the damage that had in fact been discovered from the opening up that had been undertaken, and he also gave evidence as to the inferences that should be drawn as to the likelihood of damage in areas which had not been opened up. The reference for this is in particular paragraph 8.5.5 of his first report, Supplemental Bundle D, tab 45, page 789. His conclusion was it was likely that about 55% of the lifting strop compartments would contain damage. And he said that could be extrapolated to the entire roof, which contains about 1,200 lifting strop compartments. And that evidence wasn't challenged in cross-examination. Now,
By lifting strop compartments, that means between the eaves adjacent to where the lifting strops are, does it?
It means the specific compartment in which the lifting strop happens to be located. So it would typically be...
It's on the sideboards, the lifting strop.
They're on the sides, yes.
Yeah, so it's the
Within the eaves.
Yes, unhelpfully, they're all called eaves compartments, right up to the very top of the apex.
yes, but it's within the eaves of that compartment.
Yes. Yes. Now, insurers accept that the judge failed to perform any substantial analysis on this point. That's their skeleton to the Mace appeal, paragraph 50. In fact, he performed no analysis at all. And they tried to circumvent this by contending it would have made no difference. Again, we say that's unrealistic to invite this court to make such a conclusion. They seek to rely, paragraph 54.2 of their respondent skeleton, on Mr. Coulson's evidence that the bays inspected in 2022 would have been in good condition in July 2017. Well, that was Mr. Coulson's conclusion based on his review of photographs taken on opening up in 2022. We say it doesn't assist the insurers because, as the judge held, Mr. Coulson was applying the wrong test. So Mr. Coulson's idea of good condition is not a sound or relevant one. Mr. Coulson would have described a bay as being in good condition, even if it was manifestly decayed, as long as he thought there was no structural impairment. And that was a judgment that the judge held wasn't for him as a wood science expert to make. That's a matter for a structural engineer. The judge made that finding at paragraph 120. So we say that the judge's failure to make any findings in respect of damage at lifting strop holes was again a material failure to consider a material aspect of the claimant's case. And although time is against me to develop it, we make the same points in relation to roof light upstands, insulation, and soft spots. And my Lord, as my time has run out, I will have to rely on what we've said in our written skeleton on the remainder of ground 7 and on ground 9.
Thank you. All right, we'll adjourn there at 10:30 tomorrow.
Equal rights of able.